The CPI report, Child Protection in Iowa, is brought to you by VOCAL, Victims of Child Abuse Laws. Telecast times are Sunday afternoon at 1 o'clock. Again, we repeat the program on Wednesday evening at 9:30, all on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com, or we appreciate phone calls from parents. My number is 515-276-3956, and John's number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI stands for Child Protection in Iowa, and we see some rather serious things in this business of protecting children. They get one story, and it seems as though they want to carry it to its illogical conclusions. The whole idea of get tough on crime seems to be having its heyday here in the Iowa General Assembly and in other places as well. It seems as a shame that we set aside reason and we set aside things that make sense when we stack up all kinds of laws. And we're going to be looking at one that the General Assembly gave some consideration to, and the Senate passed 50-0. That's as good a score as you can get in the Senate because they only have 50 senators. And the House File 619 passed the Senate with all kinds of problems with it. And I'll have Don and Terrance Walker chiming in on portions of that bill as they see strange things in the bill. Doubling penalties, is there any study that shows that doubling the penalties will reduce the crime? I don't think so. At least they haven't shown it to this citizen that doubling the penalties will reduce the various crimes that they're talking about here.
I think the only thing it may double is double the jail population.
Right, and also the cost. And by the way, whenever legislation goes through like this, what they're supposed to do is that they're supposed to really look at such things as what will this bill cost? And that's called a fiscal note, FISCAL note. And we'll be looking at some of those fiscal notes as we look at House File 619. We haven't had this long enough to really get into it in depth and to look at all of the amendments that were stacked in on top of this thing. At this point, at the time of our telecast recording, the House has not had an opportunity to look at this once again. They're the ones that originated it, but when it goes to the Senate and the Senate chimes in with all kinds of amendments, then it has to go back to the House for concurrence. They may have attempted to get that concurrence prior to getting it through the Senate, but I rather doubt it. So now we'll have to ask 100 people if they would like to jump on this bandwagon and champion the cause of get tough with crime. It hasn't worked in the past. I doubt that there's a strong likelihood that it will work in the future. So Iowans, you're going to pay a hefty price for House File 619. I noticed that in the fiscal note that by the year 2010, which is only 5 years away. This will be costing the state $10 million to run all of the things that they need to run in this program. By the way, they're also setting up a commission, and it seems like every time they turn around, they want to set up another commission, which means that you have to pull people in from all parts of the state. You have to have the same number of men as women, the same number of Republicans as you have Democrats, and you have to have them geographically balanced. And I don't know where you find that many balanced people to put on a committee.
News. How about that?
What's that?
Fox News.
Fox News, okay.
Fair and balanced, aren't they?
Fair and balanced. Just give each of them a camera and let them do everything on ICN television. I suppose would be the fairest way to do that. That's the way they make the prisoners bring their petitions before the court, is by video access on the Iowa Communications Network. And that thing also was another boondoggle that dates back to the late 70s, early 80s, when they were going to build a system for $25 million, and it turned out a little higher than that. It turned out to be $455 million before they got through with it, and still it is not adequate. In fact, it's out of date by now, because a few years have gone by. Some in excess of 20 years have gone by. And in high technology like this, things do move by quite rapidly. Well, this bill, House File 619, is one of those knee-jerk reaction types of things that people eat up. It also is a good bill for people who say, let's get tough on crime. And anybody who says anything to the contrary, of course, would be seen as coddling criminals or approving of the behavior. And this certainly is not true. But it doesn't. One does not escape the accusation that you would be coddling criminals, or that you would be approving of the kind of behavior that we saw in the Cedar Rapids case, where a little girl was kidnapped by people she knew from a mother who may not have given full supervision and attention to a 10-year-old who needed that attention. She was either 9 or 10, I forget which. And because of that, she lost her life. And I'm not sure, it would be interesting to get some history on the gentlemen who were involved in this particular case, because both of them were child abusers. I'm wondering where they learned all of that, because it was back in the 70s and 80s when they were doing a lot of chatter about teaching sex education classes. And they ran into a firestorm because people of Iowa didn't want their schools to be used as a teaching grounds for this kind of matter. So what they've done essentially is to teach the same stuff and call it sexual abuse classes. In the little town of Centerville, for an example, and I'll show you what can happen here when you have a misdirected set of public policies being implemented. In the little town of Centerville, children were being coached about protecting themselves from sexual abusers. Is there anything wrong with that in the school? Well, usually there's not enough time to teach the 3 R's. They're complaining that they don't have enough teaching time to teach the basics, so now we have to open it up for all of these other classes. In this one particular school district, DHS people who were being funded by the Department of Human Services would go into the schools and teach these sex education classes under the guise of sex abuse classes and get the kids pretty excited about the subject matter. And you know, a second grader will do everything they can to please the person who is doing the teaching. And of course, they desire the attention and so forth. So the person doing the presentation, not the teacher in this case, it may have been a school counselor or someone from the Department of Human Services agencies, one of the county council people, and sometimes they do that under contract that is paid through DHS funds or child protection funds. Now, these children were told the whole story about sexual abuse, and then they would be asked to put their heads down on their desks and close their eyes and raise their hands if anything like that has ever happened to you. Well, you see, for every hand that was raised, this represents another sexual abuse case that can be turned over directly to the Department of Human Services for investigation. I contacted the school and complained that that was going on. They said, oh no, we're not doing that. And I contacted the Department of Human Services and says that that was going on. Is there anything in the code that permits them to do that? And the Department of Human Services said, yes, that was going on. And yes, they do have authority under the code to tell kids to put their heads down on their desk and close their eyes and raise their hands, which I think is totally ridiculous. I think it's a misuse of public funds going to education and then being diverted to some other game. Now, what would be the consequence of this happening? What we're doing is we're asking 100% of the public school population to be subjected to the thoughts and whims of an outside group coming in and telling them about sexual abuse. First of all, children are not generally abused by strangers. So when they come in and talk about stranger danger, that's off base, because there are, the percentage of stranger danger hazards are extremely small. In the Josetta case, it was not a stranger danger. This was somebody that she knew. Well, back to the consequences in this little town of Centerville. I guess it isn't a little town. It's a rather thriving town and a go-getting type of cooperative village. Well, at any rate, what it has done, it has awakened interest among children who are 7 and 8 years old that need not be awakened. It might be interesting to have their interest aroused in such things as phonics, or in arithmetic or mathematics, or in science, but we need not raise their consciousness about such intimate matters as this in a school setting, and then cause that then to be a topic of concern among the children and a topic of their conversation, and in many cases a topic of their activities thereafter. So we have some girls who decided, because this one little girl was reprimanded for not getting her work done, decided to use that opportunity to slam dunk her teacher. Is that a consequence? Well, some people say, well, we were really protecting the children. Protecting the children from what? Here's a girl who had not been molested, but yet she saw this as an opportunity. And by the way, she isn't the first one who sees this as an opportunity to gain that which could not be gained in any other fashion. 2/3 of all cases of child abuse are turned in, most of those falls, in divorce and custody issues. Why do you suppose that happens? Well, it happens because it's a convenient tool and it has all kinds of sanctions which protect the accuser and really make it difficult on the person who is being accused to protect him or herself,
Or to get their child too.
or to win the custody of the child.
Yeah.
So it really slam dunks. Now, did it end there? No, because this teacher was charged by the county attorney based upon the testimony of the children. And we always say, you must believe the children. No, you must use your common sense and subject those children to the same kind of cross-examination as you would anybody else. Their word is not more valid because they're young. And by the way, their youth does not discredit them, because children as young as 3 years old can give a valid story. But if we believe everything that the child says without some good reasoning to back it up, we will be in real trouble. So now the teacher is placed on trial. This is going to cost the school something, because they have to pay him during all of this business. So the teacher's on trial, and they aren't satisfied that there was a hung jury in the first time around, so they have to try him again. Now, what has happened with this little girl? We have a little girl who was fully protected, fully watched over, well taught by a highly skilled teacher, who decided to use the system for her own ends. Was she 8 or 9? I forget how old. I believe this one was 8 years old. And she was able to gather that information by listening to a contract worker from the Department of Human Services who told her to put her head down on her desk, close her eyes, and raise her hands if anything like this has happened. Well, they're doing this all over the state, and the schools are welcoming this kind of program in the schools, to the discredit of the children, the teachers, the community, because now Centerville is a divided community. And I heard one lady make a comment about that, and I mentioned it on this program, that she said, even though the teacher was found to be not guilty, there are still lots of questions. Why should there be questions if he was taken to court and 2 juries were unable to find any flaw in his character or behavior? I was hoping that he would stay with the school, but I've been told that he has submitted his resignation and will no longer be teaching in the Centerville schools. However, the rottenness of the behavior of the Department of Human Services remains. The fact that they can come into a community, awaken interest in children that should never be awakened. They don't need to be awakened regarding these interests. They do need to be protected and watched over by parents, their church staff, their neighbors. They need to be watched over, but they don't need this information regarding sexual abuse in the schools, nor anywhere else for that matter. In fact, they don't need the sex education information, according to Dr. Keyes, until a week before they get married. What do they need that for? They don't need to know all of this garbage that is leading our system so far astray, and is not protecting the children. Certainly not protecting the children from harm, is it, when we go this far? Let me say one other thing about the Jacetta case. That was a tragic situation. And it should not, tragic situations should not drive our political system. Common sense should drive the political system. Reason should drive the political system, not these high-profile cases. And you're seeing this all the time, where we're getting bills named after the tragic one tragic situation after another.
Well, I think it can be adequate. The Senate's reaction in this matter could be adequately coined as legislative lynch mob mentality.
I believe you're right. I think you used the right term.
They seen the story flash across the TV screens and the newspaper the past couple weeks, and they said, "Oh, well, here's a hot button issue. Let's go to work on it and make a new law."
Right.
So we can seem like we're tough on crime, when in actuality, the true crime they need to be attacking is the crime that takes place in the courthouses of this nation and in this state from despotic judges. But that's another subject.
Okay, right. I thought I was going to get down into the case itself, but I want to turn some time over to you to talk about some of these other items, Terrance. This case is one in which was driven by the Jacetta case, and basically what they're doing is they're doubling the penalties. Is there anything that shows anywhere that doubling the penalties will reduce the crime? Show me evidence of that. Otherwise, get off this kick, because the fiscal note's going to come in and say what it's going to cost us to do that, to have people in prison twice as long on these cases. And by the way, I've seen a lot of innocent people go to prison on these situations, and many more take a plea bargain because they know the system is so rotten that noting what could happen to them, they're willing to plea something down to a lesser charge, just in order to get out of the situation and not have to serve the time. Now the plea bargains will probably go up enormously because of the fact that people won't want to serve twice as long. Well, we're going to find ourselves out of money one of these days because of these things. And I know one of the leaders says, well, if it takes putting all these people in prison, we'll build the prison and we'll find the money to do it. Now that's a pretty ridiculous thinking in my way of judging this. It seems like to me they ought to use things that work, and it's a shame that we have to even talk about crimes of this sort. But sometimes we need to stop and reason together before we tie these things down to long prison terms. I had an article on that. I hope to get to, if I don't get to it this week, perhaps next week. But before we do that, before we get too far into our battle here, we better switch over to Terrance Walker, who has been so good to look up cases and to give us some kind of a slant from the judicial standpoint here, because until we get the judiciary straightened out anything we do from a legislative standpoint or from an executive branch standpoint is totally worthless. So let's now uh, uh,
Just call me the judicial correspondent slash chief judge of the Iowa judiciary.
and
That's
you better watch the slash because they may get you for going armed with intent.
well, that's fine.
Okay.
I'm fearless at this point.
Okay.
Because they can kill the messenger, but the message is going to get out.
That's right.
And since I've been so persistent in getting this message out, the message is going to live on, and therefore I will live on through my message. So either way, but anyway, what I'd like to say, yes, my name is Terrance Walker. I'm the self-appointed chief judge of the Iowa judiciary. You got it. No robes, no capes, no false airs, just pure facts, unadulterated. There's a couple of major stories that have been baking here throughout the news as I wipe off my face here. Lights are a little hot. But there's 6 weeks, there's been 6 major stories that have surfaced across the nation about judges and their dealings. One more important one was when Terry Schiavo died a couple of weeks ago. There's been a couple of different instances where there was some judges that had family members touched by violence. Wanted to look at a couple of these different things. One was a comment also that has sparked some controversy from House Majority Leader Tom DeLay of Texas. After the Terry Schiavo incident, he said, "We will look at an arrogant, out-of-control, unaccountable judiciary that thumb their nose at Congress and the president." And not only that, but he's issued a number of attacks, verbal attacks, that is, on judges as well. David Barton, of course, you know, through all of this, the judiciary's response has been that, well, we've got to maintain our independence. So, you know, we can't be influenced by these people, and we just make up our own minds, which, you know, that does have some credence. However, as David Barton of Wall Builders, which is a group that seeks to draw attention to religious roots of the U.S. government, he says that independent is an interesting thing, because if independent means unaccountable, that's wrong. We have no unaccountable branch, nor would I say should we. And yet and still, you'll hear a lot of judges claim that their independence somehow is supposed to be in a place, and they tie that together with their unaccountability. Unaccountability meaning there's no branch that really checks the judiciary at this point. There is impeachment provisions within the Constitution which allow federal judges to be removed, and some states, like Iowa, do have the ability to have the populace vote judges out when their terms for retention are up every 2, 4, 6, or 8 years, depending on what level of judge they are, which is what our group here, that's spearheaded by me, Vote Iowa Judges Out, VJO, is doing. And we're actually promoting that. The judiciary, according to the Constitution, represents an equal branch of government that by design is supposed to interpret the law and not bend the law. And Kenneth Starr even completely agrees that as a coordinate branch of government, the judiciary is appropriately subject to criticism. Now, one of the other comments that evoked a firestorm of controversy was when another congressman, I believe, after the murder of the husband of one federal judge, and also the Atlanta incident, Corn mulled a possible connection between the perception in some quarters on some occasions where judges are making political decisions, yet are unaccountable to the public, that it builds up and builds up and builds up to the point where some people engage in violence. And he later backed off these remarks after his remarks evoked some controversy, provoked some controversy rather. But Supreme Court Justice Sandra Day O'Connor cited an increase in threats and recently said that, oh, I don't think that the harsh rhetoric helps. I think it energizes people who are a little off base to take actions that maybe they wouldn't otherwise take. Well, I do think that there is some basis, like John Corrin said, of Texas, for this connection. When people feel helpless and hopeless, and feel they have no other avenue to pursue to remedy their frustrations with a person, place, or thing, then it may erupt in violence, and I think that's what we're seeing. To take, for example, in Maryland, one of the groups that I'm affiliated with, Matter of Justice, which is available at www.amatterofjustice.org. You can look up their website. One of the group's leaders had embarked on a fact-finding mission to determine what percentage of people that represent themselves in federal court are actually getting a hearing. And in 2002, he determined in one particular county, one district court, went through all the filings, all the lawsuits that were filed by people that were representing themselves. And surprisingly, 0 cases out of the many that he's seen, hundreds and hundreds of cases, 0 of them had actually been granted a hearing. And, you know, I know that people are not, the average ordinary person is not able to file something with the precise legal language as a lawyer and to meet all their meet all the deadlines and all of that. However, it's highly unlikely, given the vast number of cases that were filed, that everybody could not have filed their stuff properly and could have not deserved a hearing. But these are the kind of things that's going on in America right now. Thought that we bring that out and thought that'd be appropriate for discussion right now. Did you have any comments on that, John or Don?
Not at this point.
No, okay. I thought you might wanted to share that or say anything on that. One case here that came up here I thought was interesting here in the Iowa courts, Iowa Court of Appeals that is, was Isidro Ramirez versus State of Iowa. This is an April 28th, 2005 case in the Court of Appeals. This was a guy that was appealing on post-conviction relief, which is like basically a second appeal. He was appealing in front of the Iowa Court of Appeals his conviction for murder. Well, the thing that I find interesting about this case was that in this case, at the hearing, the district court dictated its ruling into the record and then asked the prosecutor to prepare a written ruling in accordance with the court's findings and conclusions. And then what he did is he signed it. So we have a prosecutor that is doing the judge's work, when in actuality you're supposed to go into court and there's supposed to be 2 sides, 1 referee. When the referee takes a side, he's no longer a referee. And I agree with Judge Sackett, one of the only judges that I admire on the Court of Appeals. Judge Sackett says, I would strike the ruling prepared by the prosecutor and remand it to the district court to draft its own ruling. The district court's decision to have the prosecutor draft the written ruling deprives me of the judgment that the district court exercised in signing the ruling. It also impacted on Ramirez's right to a fair trial and gives the appearance of unfairness. I recognize the district court did dictate a ruling in the record, but I do not believe that this should relieve the district court of preparing its own ruling.
Right.
What is even more troublesome is that the ruling prepared by the prosecutor contain factual and legal errors. And that's something that we've been talking about throughout this show since I've been on here, is that the ultimate injustice is when a judge makes up a case or decides a case and changes the facts or takes liberties with the facts. And instead of interpreting the law, they went ahead and changed the facts so it meets whatever they're saying. And this is one of the few instances in which you have a judge admitting that a judge is basically allowing the falsification of facts in their courtroom. I submit to you that this happens a lot. In one case in particular, one case that I was involving myself, that's actually before the Iowa Supreme Court right now. The case number, and I'll say it at the end of the show, it's 03-1173. You can look that up online on the Iowa Supreme Court's website, and you will find that the facts have been changed, especially if you go look at the briefs. So that's just my take on the whole issue. One other thing I wanted to add. Did you have comment on this, John or Don?
Oh, yes.
Okay.
I wanted to comment on how the attorney, I forgot how you worded it now, about the judge making a verbal statement, I believe, in court, and then the attorney does not follow that direction. I saw a case down here in Polk County. A friend had a hearing with the city zoning, and I went down there and I sat right up there at the table with him as a friend, and nobody objected, and the case went for about a half an hour, I suppose, and the judge made a verbal statement saying, this is what needs to be done. This defendant here that I was sitting beside, he needs more time. You're not giving him the time. Now, and then he turns to the attorney of record, or attorney that's sitting there, the city attorney, and he said, now I'd like for you to write up a order based on what I just said. And the attorney him-hawed around and said, okay. And so the judge, he was an older judge, and he probably wanted to take a break. And so the judge went back to his chambers and for about 10 minutes. And the county attorney wrote up the order, handed it back to my friend, and I said, you want to read that over before the judge comes out, make sure that it's correct. And so he read it over, and it was totally contrary to what the judge had told him to write. And I said, when the judge comes out, bring that to his attention. And so he did. The judge comes out, and he said, Your Honor, this ruling that the attorney wrote up is not the same way as you had prepared, or you had stated verbally that you wanted. And the judge said, well, let me see that order, the ruling. And so the judge looked it over. He was ticked off with that attorney. I told you to write up this certain way, and you didn't do that. Well, if you can't do that, I guess I'll have to do it myself.
Which judge was this?
I don't remember. He was a semi-retired judge out of Indianola. They brought him up to hear the case, and I don't remember the name. Do you remember, John?
No.
Okay.
That's incredible. Well, you had an incident where this happened to you, didn't you, John?
That's right. Well, it seemed as though the individual that was the prosecutor seemed to have an awful lot of input into the system. In fact, I think he wrote the ruling for one of our favorite judges down there by the name of Joel Novak. And because the judge's ruling was based upon facts, not in evidence.
Exactly.
Now, how do you get facts not in evidence?
Can
Well, you
explain
go.
what that mean, though?
Yeah, you
That's
go
what
to the
you're saying.
prosecutor. You go to the prosecutor, and the prosecutor knew how he was going to fight the case. He knew what he thought to be the facts, so he simply wrote those facts into the case, and the judge ruled on them, including the fact that. Um,
Or you mean the incorrect fact?
Right. Well, the facts as he knew them,
Yeah.
the facts that as a prosecutor knows them, you can consider those to be incorrect facts.
Yeah, exactly.
Without naming them even. Well, so he used those facts, and the judge simply signed the order. Well, that's a good way of winning a case, is to go in and sign all the or prepare all of the pretrial orders, so that you can't possibly lose.
Yeah,
In
and
the,
I think the significant fact that they did on that they made incorrectly in the ruling um, must have been the prosecutor in collusion with the judge, was that the incorrect statement that the complaint that brought you to court in the first place was signed under oath, which there was no proof on the thing, and anybody that had an elementary understanding of what an affidavit is would have seen that there was no notary stamp on there. It couldn't possibly have been under oath.
but the order, which you call judge law, the order said that there was an oath. Well, who wrote the order? The prosecutor
I believe
obviously
the prosecutor must
had
have
written
wrote
the order.
in your case too.
Yeah.
An interesting side note on that: I seen your favorite judge, the one that you're talking about here, Judge Novak, this past weekend over at Prairie Meadows, and I heard he's a regular there. So I think we should give him a new name.
Yeah.
How about Racetrack Novak? So if you're going to court in front of Mr. Novak next time you see that, ask him how much he lost on the horse races.
Right. I know when you asked me about it, the first name that came to my mind, racetrack, gamble.
Yeah, there you go.
Are you
Well,
sure
I
you
tell you
lost
what,
money?
We're all gambling when we go to court
That's right.
in Iowa. You best
Um,
believe that.
You know something, don't you, about people orders that go to the Polk County Court, and the order says that it has to be
Under oath.
notarized. Yeah, Polk County Attorney's Office has dropped charges against a soap opera actor because the police did not notarize a ticket filed against him. Jason Cook of Days of Our Life was arrested March 7th after police said he tried to take a marijuana pipe onto an airplane at the Des Moines airport. He was charged with public intox and possession of drug paraphernalia. Cook was in town for the Variety Club telethon, and he plays Sean Brady on the daytime television series. So there in Polk County, dress orange, is Jason Cook.
Well, I'm surprised they didn't manufacture facts on in his case as well and try to say that the notary was under oath.
Yeah, where was the prosecutor? Where was the prosecutor that should?
He's lucky he didn't have Judge Novak.
Yeah, absolutely.
Did
You also wanted to.
Yeah, I wanted to show that case for future reference, that Ramirez case where they were talking about where even though he lost the case, which is surprising, I guess it's according to the courts here in Iowa, it's all right if you have a judge that goes by factual and legally incorrect conclusions in their order, which was made by the prosecutor. It's all right. You're going to get your conviction affirmed. So that's what happened to Mr. Ramirez there. One other story here I wanted to touch upon before you go back to your other story there, John. Here's something from John Hartog out of Pottawatomie County, and he's freeing the wrongfully imprisoned, and he's been doing that for years. He has a little bit of involvement with the Terry Harrington case.
Should
What
we
was you gonna
welcome?
say?
Should we welcome our audience in
Yeah.
Pottawatomie County?
Yep, Channel
They
23.
call They call
Cox.
it Channel 23.
23. You
Okay.
bet. Metro 23.
Call it Pot County over
What
there.
town is that near?
We're talking about Council Bluffs. You bet. In the also the Omaha area. I believe.
So welcome.
Yeah, welcome again. But John Hartog from that neck of the woods, freeing the wrongfully imprisoned. He had a little bit of involvement with the Terry Harrington incident, not the incident, I should say, the freeing process.
Is
He's-
Triumph.
Triumph. There you go. A victim of a botched trial, a wrongful conviction, a wrongful sentence, life without parole. That's what John Hartog says about Jeff Ragland of Potawatomi County. He said this in front of Tom Vilsack, the governor, December 13th, 1999. A little bit of background about Jeff Ragland. He was an unfortunate teenage brawl at 1 o'clock a.m. on Saturday, August 16th, 1986 at a Council Bluffs supermarket parking lot. And it ended up with the tragic death of 19-year-old Timothy Seif. And the three 17-year-old youths and a 24-year-old male were charged with the killing. And a Des Moines Register article in 1994, May 29th, picked up the story of the four involved in the deadly altercation. And that's when he became intensely motivated to get Jeff Ragland out of prison, because he felt that this article reflected undeniably some lucid corruption of justice, and Ragland became its victim. And he quotes the staff writer of that article, Tom Witowski, as saying Jeff Ragland didn't kill Timothy Seif, but he's serving a prison term for life without the possibility of parole anyway. And Matthew Gill killed Seif, but Gill was freed on parole after serving just 28 months of a 50-year sentence.
That was on a plea bargain.
Yeah. Well, I guess if you play ball, like they say, you get off light. And the interesting thing about this is that I believe it involved one of the same prosecutors in the Terry Harrington case, Joseph Harvey. Isn't that correct?
That's correct.
Okay, and he prosecuted the two cases and for the Potawatomi County Attorney's Office, and offered to let Gil Ragland and two companions plead guilty. But you know what they do? What they do is, if you don't play ball, they play hardball with you, and they make you, if you're found guilty anyway, they give you a lot stiffer sentence. And this is what they did in Jeff Ragland's case. Even though he wasn't, I guess he wasn't the one that was convinced. I mean, I guess the jury could have found that he done this or was guilty of the crime just by association, not by his direct involvement. But anyway, instead of prosecuting him for manslaughter, I think they got him for accessory in a homicide. And that made him culpable as the person that actually killed him. So, in other words, he may not have struck the fatal blow, yet he's getting the fatal blow of justice upon him for not playing ball. And you know, this is just really, I think, unfair. You know, one guy that may have struck the fatal blow, 28 months. The other guy that was peripherally involved gets life without the possibility of parole.
I don't think he even touched him.
Oh, he didn't even touch him either? Wow. This
I
is
mean,
this
as
is
far
incredible.
as, you know, there was a tire iron involved, and the guy did the swinging. He was the one that had the tire iron.
This is incredible. You know, but this is what goes on. Potawatomi County, Polk County, it doesn't make a difference. Iowa, United States, it's inundated. And then we wonder why we have violent outbreaks against judges. Well, you know, figure it out. Did you have any comments, John? Don?
Right. I think a lot of our public policy rears its ugly head and turns out to be inappropriate for an example, in the Georgia case where a judge lost his life, a well-liked judge, and probably one of the better judges, as I understand, in the area. But because of this wrath that we have, sometimes that causes people to do things that they wouldn't otherwise do. I wanted to finish up on this thing I talked about, Josetta from Cedar Rapids. One thing I forgot to mention is the fact that several years ago, the Department of Human Services thought it would be wise if they could protect themselves in cases where death was the final result of child abuse, if they could have permission to go over the business of confidentiality and release the story of things there. Well, Josetta, of course, died as a result of child abuse. However, the department says, we will not release the story. You see, if the story, if it's convenient and is protective of DHS, they'll probably want to release the story. But if it's not convenient, they have found another way. They said, well, let's let that decision be made by the county attorney, where the county attorney wants to release the story or not. Isn't that special? That they can detach themselves from things like this. Don, you had a story that Leslie Wimberly had written that I thought was a fairly good comment on our judicial system. Would you let us know a little bit about what Leslie Wimberly? By the way, Leslie Wimberly is a member of VOCAL, Victims of Child Abuse Laws, and I believe she lives in the state of Arizona, and our coverage area doesn't quite reach Arizona as yet. But here is a story from Leslie Wimberly. Don?
And you know her when she was in Pleasant Hill. She used to live there, didn't she, John? Okay.
No, Pleasant Hill.
I thought she came from the Des Moines area.
No.
Oh, okay. Sorry. Thinking of another woman, I guess. Anyway, this article Leslie wrote, states, back in the 80s when all this child abuse hysteria began, I thought that the eagerness in which we Yanks sought to put away criminals, in particular those who were branded by accusation of child abuse, was due to the fact that there was nothing really going on to feed our human hunger to seek an enemy. We had no war. We had a civil rights movement that at least attempted to correct the horror or racial bias. We had come to a point where we were more accepting of religious and lifestyle differences. Of course, I have to add the caveat that bigotry in various forms still exists in our country. We simply hide it better. So, who were we going to defeat next? It appeared that our society needed to have an enemy. When the upsurge of drug abuse, parentheses, we have lost the war on drugs, even though we still fight it, in parentheses, crime appears to be with us. And tired of crime, citizens seek the help of their politicians. Politicians seek re-election, and one of the best ways to get re-elected is to be tough on crime. What tougher message to send to the voters than to enact law that holds mandatory sentencing? The three strikes law is the latest political white horse. Because of these laws, determining guilt and time to be served has been taken out of the hands of judges and juries, and we now have petty petty offenders serving our outlandish sentences that do not fit the committed crime. On top of this, we have overcrowded court dockets, hundreds of cases daily to be tried before tired judges. Hence the emergence of the rocket dockets. Quote, rocket rocket dockets. The docket is she's referring to in the court system when you file a court case. She calls it the rocket docket.
It means they speed through all the cases on the docket.
Correct. Speedy in some cases. Here in America, the land of the free, under our Constitution, we were guaranteed a speedy trial, meaning that once accused and arrested, one was guaranteed to quickly proceed to trial without languishing in jail waiting to be heard. Well, that just isn't done. Now, jail waiting to be heard. Let's see. Now, excuse me, I got that wrong. Now, overcrowded dockets cause suspects to wait for arraignment. One case here in Arizona, a man waited 2 years. But once one is finally arraigned and enters their plea, the rocket docket finally arranged and enters their plea. Oh, I think I read that wrong again. The rocket docket provided giving 1, 2, or 3 days for the duration of their trial. Unfortunately, in different cases, in particular child abuse cases, a good amount of investigation and education of the jury is required. But under the new rocket docket, that doesn't happen. Usually the state gets 2 days and the defendant only 1. That's true. Maybe the state might get 5 days and the defendant gets 1 day. That's just the way
I've heard of that.
During which the state takes its time in cross-examination. Once the jury decides guilt, the judge must hand down his sentence, much of which is pre-decided by a politician sitting in his or her ivory tower of election dreams. So much for justice. Now, of course, this rocket docket, so-called speedy trial process, appears to affect only the poor and middle class. When one is wealthy, the trial can go on for weeks. So the fastest growing industry in our country is the prison system, warehousing criminals. Sadly, some of whom are innocent is big business. In the days of Salem witch trials, it was said it was better that 10 men go free than to jail 1 innocent. Today it appears it is acceptable to jail 10 innocent people in order to nail the 1 guilty. John?
Okay, thank you for that brief story from Leslie. I thought it summed up, and I thought it was a rather timely sum up of what is happening here in Polk County. Just double the sentences, get tough on crime, and that will solve all of our problems. And the answer to that is, Bill, we certainly need new jails, don't we, Terrance?
Yes, indeed.
Okay.
Yes, warehouse people.
That's right. Well, I want to thank you for dropping by and sharing those stories with us. I think we're learning more and more about our judicial system that should be protecting us. Certainly, we need the protection of the system, but it isn't doing that for us now. We'll see you next